All right, let's get started. We're going to get started with House Bill 833, and then Josh, we're going to go next to you with House Bill 1023. Is that right? Okay, so let's start off with 833.
House Bill 833 alters procedures that a law enforcement officer in court must follow when there's reason to believe that a child who has been detained is a victim of sex trafficking or a victim of human trafficking. It also prohibits the criminal prosecution of a criminal prosecution of or a juvenile proceeding against a minor for a qualifying offense, a violation, or an offense under 31102 of the criminal law article, which is sex trafficking, if the minor committed the underlying act as a direct result of sex trafficking, and adds the offenses to the list of qualifying offenses for which a person may file a motion to vacate a judgment if the person's participation was a direct result of being a victim of human trafficking.
Excellent. So we're all pretty familiar with the bill, but I had a couple questions on page 6. So some of the maybe intended or unintended consequences of the way that the language came into the committee. And in particular, and Jamie, if you could just help illuminate this for us or elucidate this for us. It's so page 6, lines 21 and 22, right? So the court shall dismiss the case if the court finds that the child is a victim of sex trafficking or a victim of human trafficking, and they committed a qualifying offense, violation, or offense under section 3-1102 of the criminal law article as direct result of being a victim of human sex trafficking. So I guess, so you have to file this petition, right?
So the petition is for the delinquency
Correct.
petition or anything in the juvenile court, really, under that subtitle.
Understood. So then I guess all the qualifying offenses are listed out here on the bottom of page 7, going on to page 8. But so you have a qualifying offense, and then if it's the direct result of being trafficked, which is either you could prostitute yourself or you could have been prostituted.
There could be somebody manipulating that.
Correct.
Sure.
Okay. And then, so it's qualifying offense, it's direct result of that trafficking situation. Then let's say, if you commit a crime that is not a qualifying crime under this bill, so one of these enumerated crimes, would that then be part of the case?
Right, so it would be, my read of that is that is part of the entire case. So you could have, I guess an example would be your low-level theft charge or your prostitution charge, which would be qualifying offenses. Yeah. Paired with a non-qualifying offense, which could be like
carjacking or something.
Sure.
Okay. So just to be quick, I want to follow this. So like you have one of the qualifying offenses, it's a direct result of trafficking, and then you commit another qualifying offense. Let's say you're doing something like you carjack someone. That becomes part of the case, and so that gets sucked in, even though it's not a qualifying offense, which I think is probably what the intent was, but that's not what the way it's drafted. And so you have someone that has been trafficked or is trafficking, is trafficked, commits a qualifying offense, then carjacks that person. That then gets dismissed immediately because it's part of the case.
If those two criteria are met, right, you've got the qualifying offense and it was the direct result.
So you're
right?
opening the door to these offenses. The way that it's drafted, it opens the door.
I mean, right, as part of the same case.
Okay. Second thing, so in 2015, the General Assembly established that an affirmative defense of duress for charges related to prostitution. We did that in 2015. We created that mechanism. Okay. Can you give me the elements of duress?
For duress, so there's
Just
duress at common law and then there's duress in the statute. The elements of duress at common law would be that the defendant believed that there was an immediate or impending danger of death or serious bodily harm. The defendant's belief was reasonable. The defendant had no reasonable opportunity to escape the danger without committing the crime, and the defendant committed the crime because of the compelling or overpowering force exerted on them.
Got it. So then, can you talk, I don't know if, I mean, I don't know if you weren't here for the 2015, were you here for that?
No, that was before me.
Yeah. So then, what, the mechanism that we created in 2015, which is right here, I think, can you explain a little bit more about what that looks like?
So basically, that applied to prostitution and either at the same time or at, over the years, it may have all been at the same time, but there are, I believe, 2 other offenses involving human trafficking where that same affirmative defense applies. But essentially, it says that it's an affirmative defense of duress if the defendant committed the act as a result of being a victim of an act of another. What it said originally was that they were charged with violating the prohibition against human trafficking. But later on, I guess it was amended to say that it was an affirmative defense of duress if the defendant committed the act as a result of being the victim of another under the human
Got it.
trafficking subtitle.
So you could create a similar mechanism for the qualifying offenses listed under this bill.
You could.
Yeah. All right, Senator Heddleman.
So in the scenario that you just, you started that hypothetical with, if somebody does something that is outside the scope of one of these, can't you just dismiss the case and then refile the case? Couldn't the state's attorney do that without prejudice? And it's not double jeopardy. You can just go ahead with the horror that you are dreaming of.
I had spoken with Lisa Jordan about that exact issue actually earlier today, and was sort of thinking about the different possibilities, with that. It may be a scenario, where I guess the state's attorney might just not even charge the, because if you read it the way that it's drafted, if they didn't even charge the qualifying offense, you wouldn't have that issue if you just charged the carjacking and not any other offense that was qualifying. So you might not even need to recharge. You might just avoid the whole situation. It's conceivable you could avoid the entire situation just by not even charging the qualifying offense to begin with and just go after, like in that scenario, the carjacking.
Right, but the whole point too is to bring a measure of protection to the person who's being abused because right?
Well, I don't think that actually doesn't go away.
Under this.
In that provision that provides for the dismissal, that doesn't necessarily go away because elsewhere in the bill, there are provisions that talk about referral to the regional navigator and the access to services. So that, regardless of that provision that talks about the dismissal, that language is still in there about like obtaining services.
Actually,
sort of parsing through that, I guess you could. I think that the argument is, or at least during the bill hearings on it, and in the testimony, was presented that they'd rather not have the victims of human trafficking in the juvenile court system or the adult criminal court system at all. That would change because, you've got that immunity that's keeping them out on the front end, with the bill as it came to the Senate. And that wouldn't necessarily be there depending on how you amended it.
But what I'm saying is, if the scenario and concern is that somebody can literally get away with murder, I don't think they can, because you still have the ability to right? Murder's not covered under here, so you still do have the ability to go after them for murder. They don't fall within the protection of having been trafficked, right? That you don't fall within the safe harbor.
I think it would depend on, as it's drafted, I think it would depend on how the case is charged. Yeah, I think it would depend on how the case is charged because, you know, the reading of that is that if the case were charged where you had both the qualifying offense and the non-qualifying offense, like, it says that the case goes, you know, once you meet those two criteria. It doesn't say that
Well, you
just
could-
the, so I think it all boils down to sort of
How
how
you
you charge
define
it.
case.
No, the case is all part of the same charging document, so the petition would be, it would all be part of the same case. So I think it boils down to how did the prosecutor charge that or file the petition?
Okay, I'm still not really understanding the concern of someone getting away with murder. If you can still provide some protection on the qualifying offense here, and then go ahead and do what you need to do with them on the murder charge. Well, why can't you separate them? Why can't you refile for murder?
Well, you might not even have to refile if you just, I mean, if you just charge, right, I mean, you know, as drafted, you wouldn't have that issue where, you know, the murder charge is wrapped into, or the carjacking charge, or whatever non-qualifying charge is wrapped in with a qualifying charge. You wouldn't run into that situation where it's either getting dismissed because it's all part of the same case if the prosecutor never brought the charge for the qualifying offense anyways. That just doesn't even become an issue under the bill if it's just charged that way. But I mean,
Right.
the end result
that.
ends up being, yeah, it's just a charging question. But if it ends up being part of the same case, then that's where you run into that issue. But I don't think that it would ever, my guess is that it would never come to fruition if the prosecutor just never charged it that way and said, well, the prostitution charge just isn't even going to be part of the case. You know, they're just going to go with the carjacking or the murder charge. I think that, my guess is you'd have to ask a state. How they would.
The case would be combined if they come out the same factual situation.
You may not. So I guess the amendment would be to, let me just make sure I've got the right page.
Yeah, can't you just dismiss the qualifying offense, not the whole case?
Yeah, you could amend it that way, at least with respect to that. To amend it to say, instead of the case gets dismissed, yeah, you could do that with respect to that.
So we've got this amendment before us now. Let's run this amendment. If it fails, then we can consider another one.
This is the affirmative defense piece?
Yep.
Not Senate.
Right, so it strikes the language in the bill that's being added to, if you look at page 5 of the reprint, strikes beginning at line 8 on page 5, down through line 27 on page 6, and then beginning on page 7, you would have the language
Yeah. Yes.
beginning at line 12, so subject to paragraph 2 of this subsection, in a criminal prosecution against a minor or in a proceeding against a delinquent child, under Title III, Subtitle 8A of the Courts Article for a qualifying offense, a violation or offense under 31102 of this article, it is an affirmative defense of duress if the defendant or child committed the act as a result of being a victim of another under Title III, Subtitle 11 of this article. So another person. So that, yeah, I was going to point that out. Right, so it would be another person. That's just sort of read into, we use the term another in the code pretty frequently to, and it's.
Would it be better if the person,
You could. Sure.
when I read it, I thought, oops, a word's been omitted.
That is, I mean, so that's consistent with the current affirmative defense for the prostitution affirmative defense currently.
Okay.
So where are you seeing you see the word omitted, Chris? What line?
After line 15 on page
just wants to add
7
person.
of the reprint.
Right.
It says, the victim of another. Under Title III, and my question is another what? And the answer is another person. And so, it's not a big deal, but it confused me, so,
He literally lifted that from.
something else. Okay.
So what I have, the line after 15 says defense of duress if the defendant or child and committed, which, something's wrong there, right?
Oh, that word and should actually be deleted. That's a
Okay.
typo. After, the and after child.
Yeah.
Yeah.
It is an affirmative defense for the defendant.
We're just doing
Well,
grammar right now.
commit. Yeah.
Right. Under Title III, Subtitle 11 of this article, or the prohibition against human trafficking under federal law, and that is consistent with the existing affirmative defense for prostitution and those other human trafficking offenses.
Can't bring up. Center West.
So here's my question. My concern always has been that these girls, these minors are victims, and I want to make sure the victims get help. So how does this get them help? This basically says they get off from the criminal offense, which is all well and good, but does that mean they just go right out on the streets again and start pursuing prostitution to pay for their drug habit? Or isn't there some way we can assure these people that get help so they're not going to end up right back on the streets again?
Jamie.
Hold on, this is important. Can we just answer this question? It's important because he's gonna explain the process from the regional navigator on page 4.
So, Senator, if you turn to page 4 and 5, there's the existing law on how law enforcement is required to interact with suspected victims of human trafficking, and then there's new language coming in. So, if going off of page 4, starting at line 18, I'll read a couple of the lines here. In addition to the requirements of reporting child abuse and neglect, if a law enforcement officer has reason to believe that a child who has been detained is a victim of sex trafficking or a victim of human trafficking, as soon as practicable, the officer is required to notify an appropriate regional navigator for the jurisdiction where the child was taken into custody or where the child is a resident, that the child is suspected of sex trafficking or suspected of human trafficking, so the navigator can coordinate a service response. They are, as soon as practicable, required to report to the local child welfare agency of the that the child is a suspected victim of sex trafficking or a suspected victim of human trafficking, and release the child to the child's parents, guardian, custodian, if it is safe and appropriate to do so, or to the local child welfare agency if there is reason to believe that the child's safety will be at risk if the child is returned to the child's parents, guardian, or custodian.
So the assumption would be that the child welfare agency, if the thought is the child would be at risk if released to the parents or guardian, a local child welfare agency will take charge and will make sure that the child coordinates with the regional navigator for the appropriate service response. That's what you're
Correct.
saying?
And I want, Jamie could explain to us then when, if let's say there's a lack of cooperation, does that child then become a child in need of supervision, and what is that, can you explain the process? What happens if they don't cooperate?
Suppose the child fails to show up for her appointment with the regional navigator. That's my question. I mean, we're making this available to her, but there's no compulsion, and if she decides not to do it and goes back on the street, what do we do?
You'd be subject to a sens petition, which is provided for in the court's article. That's the juvenile court handles that as well. But basically, and this is an oversimplification, I can get you more information if you'd like, but my understanding is, you're not dealing with DJS, you're dealing with DHS.
All right, so there is some coordinated response, and she's not just going to be abandoned and left to go out and pursue her prostitution trade again. That's what I wanted to make sure, that we're really getting help to this victim.
But that's been in the bill. I mean, that's the bill as it came in,
Right.
right? So, but we are getting rid of the main purpose of the bill, if I'm correct, which is the safe harbor purpose. Is that correct?
Courts to a defense.
Right, but the person then has to go through the whole criminal justice process,
No,
right? And
this is the
in order
process.
to be
This is
able
the
to
process.
offer that as a defense.
They're not in jail. They can
Right?
put 'em
They're
in
not, yeah, but they're missing the safe harbor, the protection because they are a child who is abused.
All those charges.
I hear
Whereas
you.
now you're naked.
But under this bill, you wouldn't be naked.
Under this bill, you'd be immune.
That's the purpose of a safe harbor.
Where else do we do that?
This is, where else are children trafficked? I mean, we do offer protections. I mean, other states have found a way to do this.
All right.
And, I mean, Senator
What other
Leahy,
states
I
have
don't
given,
wanna,
what other states have given immunity in this sense?
my understanding is dozens.
See, I really want to see that, because they keep saying this, they give immunity. I understand what we're doing here, but I'd really like to see the states that just say,
I've never
you can be a prostitute, it's okay, as long as you're under 18, you have a safe harbor, have at it, just keep going. I just find that, if they're doing that, I find that preposterous. And Senator Carter's point the other day of, if you think, I'm sure sex trafficking is terrible, but you know what else is terrible? Is being a 14-year-old kid who's brought up in an abusive, beat the crap out of you home. And so there's tons of victims out there
Right.
who deserve every bit of the same. So what we end up creating here is an entire body of law that basically we just put, let's face it, most kids who are, from what I understand, a large body of kids who end up in DJS are there because of trauma, of some kind of youthful, and not just wimpy, we're talking serious stuff. So if we're gonna do the safe harbor, what we're really saying is, DJS, go home, we don't need you no more, we're just gonna have this to be a safe harbor, put everybody in a safe harbor, and nobody will go through DJS. It just seems like a crazy way to go to do that. Let's.
All right, I got it. Just real quick. So we made some inline changes to the amendments. Did you,
Right,
Does-
so,
and I want to keep the discussion, but I want to adopt these amendments and then work off of that as a discussion point. So is everyone okay adopting the amendments? Okay. The changes, the technical changes, moving the and are you going to add the direct?
well, so I wanted to just flag that. So the language in front of you in the reprint is different than, how to phrase this? So in the bill as it came in, that dismissal provision and the term that is being used in the bill is that it was committed as a direct result of human trafficking. But like if you look to the existing prostitution prohibition and the affirmative defense that's provided there, the language actually provides that it's that the defendant committed the act as a result of being the victim of another under Title III, Subtitle 11 of the criminal law article. So the difference is whether it's a direct result or a result. Direct result is more analogous to how the vacature provision works, where in order to vacate these qualifying offenses, you have to show that it was a direct result of human trafficking.
So do we need to change it?
You
Well, I don't see this bill, it represents the original intent of this bill to be a true safe harbor bill. I spoke with the House sponsor of this bill too, and perhaps at this late date, we can move forward with these amendments. But I just want to go on record, I do not consider this really truly a safe harbor. I see it more as an affirmative defense and a vacatur for children victims, but I don't think it is the true intent of the advocates and what we really wanted, but if this is something that we're doing at this late date, maybe we ought to just move forward, at least with this first step in protecting child victims.
I'd say it's more than just a small step, it's a giant leap, but, all right, so it's been seconded. Is everyone, do you want to do a roll call, or what do you want to do? All right, everyone's okay. Excellent. All right. Next, let's move on to, Josh will go ahead with House Bill 1023, and then we're going to go to House Bill 1062.
Mr. Chairman?
Yes.
Can we get the Senate bill out too?
Oh, my apologies, yes. Yes,
Just make it the same.
absolutely, absolutely.
Okay,
All
and
right.
could you please
No,
get
thank
it
you
out
for
of
that.
rules, please?
I appreciate that.
Thank you.
All right, so it's Senate Bill 265. That's Senator Lee. It's the cross-file.
No, it's 768,
Sorry, you're absolutely right. You were right.
SB 768.
So it's not on here, but we'll put it on here. It's fine.
Okay, can the committee vote on it?
Yes,
to
so-
Conform it?
768. It's the direct cross-file of House Bill 833. The motion would be to conform. It's been seconded. Everyone's okay. All right. Josh, you're up.
House Bill 1023 requires the Department of Public Safety and Correctional Services, the Department of State Police, the Police Training and Standards Commission, and the Governor's Office of Crime Prevention, Youth and Victim Services to submit annually to the Department of Legislative Services specified information relating to public safety and criminal justice. It also requires the Department of Juvenile Services and Department of State Police to enter into memorandums of understanding with DLS for each agency to provide certain information, and it alters certain reporting requirements relating to law enforcement. So on this House bill, the Department of Legislative Services worked with the state police on some amendments which limited the scope of the reporting in the bill to information that is currently collected by law enforcement, and that eliminated the fiscal impact of the bill. So you have the House bill, which was amended, and then there's the Senate bill you could conform that to.
Some further discussion? All right, the motions were favorable. Second. Everyone's recorded in the affirmative. Okay, great. Next, we'll move on to House Bill, and I think this is Jamie, 1062. Are you good to go?
Waiting on some copies to come out on that one.
Okay, so, all right, while we're waiting on that, you want to go to House Bill 1295?
Yeah, real quick, 1295, I'm gonna need you to hold that bill. I'll talk to you later.
Okay, all right, it's been held. All right, let's go to, got it. Yes, that's right. So let's go to House Bill 244, Heather.
So House Bill 244, this bill prohibits a calculation of damages for loss of earnings resulting from personal injury or wrongful death from being reduced based on race, ethnicity, or gender. So
Is this just, real quick, is this the exact direct cross file, similar, same
It's-
posture as the one we passed out of the Senate unanimously?
yes,
Okay. Is everyone okay with recording the same vote that you recorded last time?
Yes.
Okay, so the motion's for favorable, everyone's recorded in the affirmative. All right, excellent, thank you. Yeah, it's a cross file.
identical, unanimous.
No, that was the only one. Okay. All right, so let's do, House Bill 885. That's Heather.
So House Bill 885 is a local bill. This bill alters the annual salary of the Sheriff of Howard County by establishing for calendar year 2022 and each calendar year after, the annual salary of the sheriff is equal to the salary of a major on Step 6 of the Howard County Police Management Schedule for the first year of the sheriff's term. And two, the salary of the sheriff must increase annually according to the Howard County Police Management Schedule for as long as the individual holds the position of sheriff.
I need a hold on this bill. I need a hold on this bill.
All right, Senator Huff has asked for a hold on House Bill 885. All right. So let's go back to House Bill 1062.
Bill 1062 establishes procedures for an officer or authorized agent of a humane society or a police officer or other public official required to protect animals to petition the district court to order the owner or custodian of an animal that has been seized to protect it from cruelty or for its health to pay for reasonable costs of caring for the animal. The bill also modifies existing provisions authorizing the removal or seizure of an animal to protect it from cruelty or for its health. There are some amendments that copies are being made, and they'll be distributed, but, yeah.
All right, she's gonna wait till they get here so you can explain them to us. All right. Who has that? Who's Josh? So now
House Bill 143.
we're in House Bill 1143. Josh, go ahead while we wait for 1062 amendments to print out.
House Bill 1143 expands the definition of all-terrain vehicle and provisions governing the use of such vehicles and snowmobiles in Allegheny and Garrett counties to include off-highway motorcycles. Additionally, the bill expands the area of a highway from 2 to 5 miles on which Allegheny and Garrett counties may authorize all-terrain vehicles and snowmobiles to operate.
We just had the hearing on it. This is the bill that passed the House.
There is a Senate bill. I think it's still in rules.
Yeah, the Senate bill is in rules, so. Yeah, second.
All right. It's been moved favorable. It's been seconded. Everyone's recorded in the affirmative. All right.
Say one aside, they are super into stuff in E&T. When you've got a smaller field, they are like.
All right. Josh, we'll stay with you with House Bill 1076.
House Bill 1076 authorizes the Motor Vehicle Administration to issue an electronic or digital 24-hour registration, allowing the owner of a vehicle to operate the vehicle on a road in the state. Such registration can only be issued after an application has been submitted and a fee paid. The fee would be determined by the MVA.
There's been a second, yeah, it was a good hearing, yeah. There's been a motion for favorable, it's been seconded, everyone is recorded in the affirmative. So House Bill 521.
Pull it up.
Okay. So House Bill 521, this bill authorizes a tenant to petition the court to shield court records relating to any action for repossession for failure to pay rent. If the failure to pay rent was due to loss of income arising out of the COVID pandemic. The petition may not be filed until the appeal period for the action has lapsed. And the bill only applies to court records in a failure to pay rent action that was filed on or after March 5th, 2020, but before January 1st, 2022. The bill does not apply to any record relating to an action for repossession for failure to pay rent that resulted in a money judgment in favor of the landlord unless the tenant has already paid the judgment in full.
This is for a failure to pay rent?
Yes, shielding of court records for failure to pay rent during the COVID for the specific instance when appeal process is over, and if there was a money judgment, they fully paid the money judgment.
Defined. Second.
A motion and it's been seconded, we're gonna hold it open for discussion, but go ahead, yeah.
A loss of income arising out of the COVID-19 pandemic. So, I mean, wow. What's that?
You lose your
I guess you have to come in and put on, I mean, that'd have to be an evidentiary hearing then, right? This is gonna require,
There'll be a hearing. If the landlord does not object to it, then the burden is on the tenant to prove, to make this case.
okay, so, but I mean, the existing landlord doesn't care, because they already know the tenant's a deadbeat, or not. It's the next the next landlord's gonna be the only one that cares, because the current landlord's like, I won't rent to you again because you don't pay your rent. Who's objecting is the people with the next landlord who's saying, I won't know that you're giving me tenants that don't pay their rent, so.
But it was, you didn't pay your rent during COVID
Yeah,
because you
through
lost your
January
job.
What's this will be effective October, so it's gonna be, it'll have been.
So it's
like
effective
10 months.
October 1st, but it's only for failure to pay rents that occurred between March 5th, 2020
Yeah.
and January
January
1st, 2022.
It's not a blanket.
Yeah, it's
And that's
only.
normally because of COVID, right? It's not like a blanket,
Yeah, it's only
coverage.
during that timeline if it was
Yeah.
loss of income due to the COVID pandemic.
okay.
That's what it says.
Down? Let's do a roll call. Who's down on this? It's passing, so, but. Do you all need a roll call on this? No. Okay, so are you up or down? Cassidy's down? Oh, you're good. Oh, you're up. Okay, oh, everyone's good. Okay, all right. All right. Got it. Okay. Passes unanimously. Do Costa Care. Don't worry. Get out of here. Another dog. We're waiting for the amendments. We're not, we'll get it done before we get out of here.
This is conditions of pretrial release from detention oh, it's Josh, sorry.
So as passed by the Senate, Senate Bill 704 extends the provisions of Chapter 597 of 2021, which prohibits a pretrial defendant from being required to pay private home detention and monitoring fees or for monitoring devices under specified circumstances, and specifies that state payments of such fees are subject to the availability of federal funds. Finally, the bill extends the termination date of the work group on home detention monitoring. The House amendments alter the composition of the work group by removing 2 representatives of private home detention and monitoring agencies.
Senator Howland would like to speak. It's her bill.
It's 791.
Sorry, no, not 704.
704.
704, sorry, my bad.
Senate bill.
It's a concur, not concur. Yes,
Oh, we wanna not concur. 'Cause it-
Wait.
they take-
agreed, but go,
Can
let's,
I-
yes, Senator Heddle.
Can I propose that we split the difference and put 1 on? And so we, correct, and then
But that's gonna be not concur, so you better,
not concur and then conference, is that what you want to do?
in the conference, if you're gonna do that.
Has someone spoken to the chairman?
My understanding is that they weren't his amendments.
Maybe it'll just concur.
I was told that these companies have been relied on over the last year for a lot of information. I didn't have anything that deep to say. I was just like, I was told these companies have been relied on over the last year during the course of this for information multiple times, and that, they feel like it would be a disservice to the whole process if they were removed from the work group. So, I was just sharing that. If we don't concur and we just stick this Senate bill, what do you think
Wait,
would happen?
we're gonna go to conference and then,
Conference.
yeah. Yeah, that's fine. It's a good idea, I mean,
Okay.
who do you want to be on the conference? All right, so the motion's for not concur. And we'll go Carter, Bailey, Waldstreicher. Yeah, so let's do Carter, Heddleman, Bailey.
Do you have any intel about why they did take them off over in house? Is it? Why don't we have a conversation? Is it gonna be a hard sell or a need?
So Senate Bill 452, the recommendation, I would say, is concur. As amended by the House, it is identical to the cross-file as passed by the Senate. So it was the small claims examination in aid of enforcement and interrogatories in aid of execution prohibition. So a concur would mirror what you did earlier this session.
Which bill?
So this is
452. 452.
Senate Bill,
But what's the House bill? It's not a House bill.
the cross-file. Yeah, the cross-file is House Bill 349, so the House's amendments reflect what the amendments that the Senate did to House Bill 349, which has already passed. It would be concur.
Concur. That's the motion. I'll make a motion to concur.
Yeah.
And you just record the same vote. Okay.
Yeah.
All right, everyone's fine? All right.
House bill 1. We've got both of these. This, I think, would probably be. And then we have vehicle laws, do we have this one?
There's like 100 amendments.
This one?
What are we doing with House, Senate Bill 586? Okay, let's scrap that. We're gonna go back to House Bill 1062.
So House Bill 1062, there are 4 amendments that were provided by Delegate Moon's office. They are
3:30, it's already after.
the first of those amendments is Amendment 213221/1. And what that does is on page 2 of the bill, alters a provision of existing law that's being modified by the bill, so it would now read, "A person who seizes an animal under subsection C of this section shall notify the animal's owner, custodian by personal service or certified mail within 24 hours of the seizure, and any administrative remedies that may be available to the owner or custodian, and if the administrative remedy is not available, the right to petition the court for the return of the animal under paragraph 2 of the subsection, including instructions describing how to petition the court for return of the animal." So that would just be the notice that gets given to the owner.
Is everyone okay adopting the amendments? All right.
Which ones, all these ones?
That was just the first one,
First one,
yeah.
which number?
That was 213221/1. The next amendment is Amendment 733826/1. This is on page 3 of the reprint. Would provide that if livestock is defined in 1101 of the agriculture article is seized, and the owner has not filed a petition for return of the animal, an officer or authorized agent of a humane society or a police officer or any other public official required to protect animals who represents the seizing person shall file a petition for the continued possession of the livestock and reasonable cost for carrying of the livestock, including the provision of food, water, shelter, and medical care.
All right, wait, so everyone, motion to adopt the amendment, it's been seconded, everyone's okay, got it.
Okay, the next one is Amendment 113121/1. This is page 7, and this looks technical and clarifying. It provides that order for cost shall terminate if the animal is forfeited to the petitioner under section 10615E of the subtitle or subsection G4 or L. And subsections G4 and L have, so subsection L provides that if the owner or custodian of the seized animal is convicted of any criminal charges brought in relation to seizure, any animal seized shall be forfeited. And in G4, that is also a forfeiture provision. G4 provides that if an owner or custodian fails to timely pay any of the amounts ordered within 30 calendar days, the animal shall be automatically forfeited by operation of law to the petitioner, and the petitioner shall obtain all rights and privileges over the animal.
Four amendments.
That's right.
Can we talk to some points on this?
Sure, sure.
So a couple things, I'm trying to make sure, and I apologize, I should have actually given this more due diligence, because I'm trying to figure out how much this matches up with our civil asset forfeiture, because it's kind of similar. So, for one thing, I thought when we went and we reformed our civil asset forfeiture law, we went from preponderance to clear and convincing. I just think these two should kind of match up somewhat, because you're talking about a similar thing. You're talking about, in many cases, the government seizing property, so these statutes should mirror somewhat.
It's been a while since I've looked at the.
Isn't this different, that this is an animal that's already been lawful, whatever the standard is, this provides it.
No, it starts with the seizures in this. And then the preponderance of the evidence on page 4 is that you're trying to get the animal back, is my reading of it.
But 10615, the seizure provision is existing law. We're not,
Seize the animal, that isn't necessarily forfeiture. That's them just taking it out of your custody.
okay, all right, I get you.
It's just my point, is that I'm pretty sure when we did civil asset forfeiture, so here's what I'm saying is, if you have cash taken off of you out of your car, I think it's a clear and convincing evidence standard by the state. And if it's your dog now, it's a preponderance of the evidence standard. I mean, I just, it's,
Brush
I
up
think
on
that's, I don't think that's good to have two different standards like that for
So-
seizure and forfeiture.
So I think the difference is that when I seize your car or your money, it's really no cost of maintaining it versus, this is a huge, I probably seized your animal because they were starving to death or wandering on the road, and now I gotta take care of it. I mean,
I understand that, but it's the actual seizure part because it's your property and you may need it for economic reasons like livestock.
So I have the cross file. I have the cross file in the bill, and what I would say is, given the hour, if we could, Senator Huff, move the bill forward, and then if your impression is correct. No. If your impression is correct, we'll do a floor amendment to take it to.
The only thing I would circle on that. A little concerned about the 30-day calendar days as well. No one's concerned about that?
That's requested by the Horse Council in particular because as livestock owners, they wanted a speedy resolution on the issue.
If an owner or custodian fails to timely pay in the amount within 30 days, the seized animal for which reasonable costs were ordered shall be automatically forfeited. So what does that mean? Like, if I can't come up with the money within 30 days, what does that mean automatically forfeit it? That like they just come on my bank account and take the money, or like what? The animals forfeit to state custody unless I come up with the money for within 30 days.
And then you said who wanted that?
So this section actually was from our shelter partners because it's trying to ensure, say you've got a big dog fighting case, often these animals end up being surrendered anyway, and so making sure that the payments can be made in a timely manner is important to make sure that the shelter's stable, the taxpayers stay whole, but then also make sure that the animals, if they're going to end up being forfeited, and then also not on any language considered.
I mean, I understand why having a time frame. I just think if it's like a horse and it's let's say the vet comes back with a $3,000 bill or something, or $4,000 bill, that might be tough for somebody to come up with that within 30 days. I mean,
That's why those costs are capped very aggressively, so the medical is capped at
$50 a day.
so you're not gonna see, honestly, the shelter's not even under this gonna recover their full cost, but it keeps them closer.
So there's no other cost. There's no other cost they can add in this. Jamie.
Daily care and then that capped veterinary care.
Check on that, just give me a moment.
I mean, that's all I have. But I was, as I was leaving, I was here once before. We did civil asset forfeiture twice because once we messed it up, and then the second year we had to come back and fix it.
Page 5, beginning at line 14, reasonable cost of care for a seized animal shall be limited to $15 per day per animal in addition to necessary medical care as determined by a licensed veterinarian and documented by invoices. Necessary medical care may not exceed $50 per day.
So does that mean the $65 a day is probably the max?
That's,
So I would move the adoption amendments.
I just want Jamie to just double check that, that's all. Because to be honest, as long as that's what it is, I'm good. But if it's something more than that.
I know, and your direction is the same as mine. We're not seizing kitty cats, we're seizing cows and horses, and it's really darn expensive. And that's the challenge we have, is somebody's gotta pay for this stuff.
I get it.
Yeah.
I mean, I've voted. This has been around a long time. I
Yeah, I know.
voted for different iterations of this multiple times. These are just technical questions.
So what are we gonna do?
Well, Jamie, Jamie's looking it up. He's gonna give his question 1 second. Okay, I'm fine then. I'll look up the other standard.
Adoption amendment's been moved, favorable committee report's been moved, second, everyone's recorded in the affirmative. Favorable with amendments is what I said, that's what I thought I said. All right, there you go.
Look, he got it for you. Do you see that, Jill?
Oh, look at this. Finally, you've got my credo.
Very quickly, just say, I don't know what to tell you. In a bad.
Hey, just real, before everyone walks out, for the spousal defense, there's a concur, not concur. I know we're going to conference, right? So the motion being to not concur, force conference, right? Yes. Okay.